So there's a lot to talk about in terms of independent contractors and employees and the differences and the new law. And I want to start with just a little bit of background. I also want this to be a useful conversation for you. And so even though I have this very detailed outline of things I'm planning to talk about, I don't really care that much if we follow my outline or not. And so please feel free to interrupt me and ask me questions and steer me on a different path if that's what's interesting and useful to you, okay? So I'd like to start with, why does the difference matter between independent contractors and employees? There are a number of reasons. The classification of a worker as an independent contractor or an employee determines how the worker is paid, whether the worker is subject to the wage and hour laws, both state and federal, and whether the worker receives mandatory employee benefits. Specifically, the differences include whether the employee is paid wages through payroll with regular deductions and recorded on W-2, or whether they're paid without deductions and it's reported on a 1099. An employee has to be paid 2 times a month. An independent contractor doesn't. They can be paid less frequently. An employer must pay payroll taxes on an employee, but not an independent contractor. That makes it more expensive for the employer to have employees versus independent contractors. Employees get legally mandated benefits like workers' comp, unemployment, state disability, and in California, paid sick leave. Independent contractors do not get any of those benefits. Employees are protected by the wage and hour laws. That means if they work overtime, more than 8 hours in a day or more than 40 hours in a week, they get paid premium. They get paid time and a half or double time. It means they get protected rest and meal breaks. They must get paid at least minimum wage. None of these protections apply to independent contractors. Additional costs for an employer with respect to employees may include things like health insurance, 401k, paid holidays, educational reimbursements, expense reimbursements, a variety of things. None of these things are going to apply to independent contractors. In terms of these additional employee benefits, some questions may arise if, under the current law that we're going to talk about, some workers need to be reclassified. They may be currently independent contractors but should be employees, and questions are going to come up about, well, then do we have to give them all these additional benefits? Probably yes. But what if your organization is on a limited budget? We only have funding for X, and now we have all these extra workers that we're going to need to classify as employees. What do we do? There's a lot to think about and talk about there, but what you're not going to do is say, okay, you used to be an independent contractor, now you're an employee, but you don't get all these benefits that all the rest of our employees get. So it may be a restructuring of who gets what or how much is paid for health insurance. Maybe you need to trim that back. Another distinction between employees and independent contractors is how much the employer can control what they do. Their work hours. Do they wear uniforms? How much direction are they given? If an employer wants to give that kind of direction and exert that kind of control, that's really an employee that we're talking about. Looking at it from the other perspective, even though an independent contractor doesn't get all these employee benefits, there are a lot of benefits to working as an independent contractor too, which for some workers may outweigh the employee benefits they're not getting. An independent contractor generally controls his or her own schedule. They work without supervision. They may run their own business. They have a lot more freedom and autonomy than an employee. This is very appealing for many workers, and for many it may outweigh the employee benefits that they're not getting. So does anybody have questions about just those general differences? That's a really interesting question, and it's become even more interesting under this change in the law, where it's really so much more difficult to properly classify a worker as an independent contractor. So I think it's going to come up more and more and more, where somebody historically has been classified as an independent contractor, and that may be incorrect. And so then the question is, well, what do you do if you're in that situation, right? And one thing that I've said to people is, I think you should think about, do you want to be an employee? Because like I was just saying, there are a lot of benefits to not being an employee, but on the other hand, you don't get all the employee benefits. So my advice has been to go to your employer from a place of patience and offering information rather than on the attack and in an adversarial way, assuming that you want to preserve your relationship with them. And just say, hey, maybe you don't realize that the law has changed, and maybe I really should be an employee, but I'm willing to work with you. I mean, you should understand that technically somebody who should be an employee is not legally able to waive that. So even if you as the worker went to your employer and said, okay, I'll give that up as long as you give me a little bit more pay, or you know, whatever, even if you were to agree to that in writing, that's not going to be legally enforceable. So the employer would be foolish to enter into that bargain with you. And if you go have that conversation, what you're really going to end up with probably is becoming an employee. So think, do you want to do that? So we're going to talk about this big change in the law and this California Supreme Court decision called Dynamex Operations versus Superior Court. But I wanted to just step back from that a little bit first and talk about what was the law before that, because that informs sort of where we are now with the new law, I think. And before this Dynamex decision, there were a number of other applicable legal standards that we as California employers had to follow. The main one, and the most important one for us, came from a 1989 California Supreme Court decision called Burello and Sons versus Department of Industrial Relations. This case involved sharecroppers, so farmers that had a patch of land and they worked for a large cucumber farming company in the Central Valley. And this farming company classified all these sharecroppers as independent contractors, even though the company pretty much controlled their work, told them what they were being paid, exerted a lot of control over them. And the share farmers sued, and the California Supreme Court agreed with them and found that they really should be classified as employees, not independent contractors. This decision set out 9 factors that have informed our analysis of independent contractor versus employee since 1989. The main and most important one of these factors was whether the employer has the right to control the manner and means of accomplishing the job. If there's that right to control, generally that worker is going to be an employee in court or under the law. The other factors, and so that's the main most important factor, but then there's this other list of additional factors. The others are whether the worker is engaged in a different business from the employer, the kind of business it is, whether generally in the world of this type of business are employees or independent contractors doing this work. The skill required. If it's the more skill required to do this work, the more likely that person could properly be an independent contractor. The less skill, like a sharecropper cucumber farmer who's just growing and picking cucumbers, that's more likely an employee. Another factor is who supplies the tools, the instruments, and the place of doing work. If the company supplies it, that looks like an employee. The length of time anticipated for the work relationship. So if it's just a discrete project, that looks more like an independent contractor, but if it's a long ongoing relationship, that looks more like an employee. The method of payment. If they're being paid by the hour, that looks like an employee. If they're being paid by the project or for a set job or a set piece of work, that looks more like an independent contractor. whether or not the work is part of the regular business of the principal, which is repetitive, another factor, but the court set that out. And finally, whether the parties believe they're creating an employment relationship or an independent contractor relationship. And that may be documented in an employment agreement, or it may just be, what did we talk about? And the way this Burello case analysis works was, it's looking at the employment relationship as a whole and balancing all of these different factors. No one factor was required, and no one factor was determinative. So it's sort of a holistic approach. There are several other applicable tests, like the IRS has its own 20-factor test. There's a US Supreme Court case that has another test that courts look at. But in California, this Burello test that I just described is what we focus on. That pretty much covered everything. In California, our public policy is very protective of workers and employees. And the courts have repeatedly expressed this very strong public policy to protect workers. They look at the court looks at workers as vulnerable, and the court looks at employers as strong and powerful and wealthy, and who should be paying to protect the workers. The courts also talk about how important it is for employers to fund and provide a safety net for workers, including things like workers' compensation, unemployment benefits, state disability. Most of these things are funded through payroll deductions, which comes from an employment relationship, not an independent contractor relationship.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.